Hello, I'm Susan, Dr. Susan van Scoyoc, and I'm inviting you to join me for coffee and to mull over a particularly interesting case. Now, before I start going into even the details of the case, let me tell you why this really piqued my interest. I have been an expert witness, in this case it was a criminal trial, where the expert on the other side advised basically his side's barrister that I was not qualified to be an expert witness, and worse, that I was not qualified to be recognised as a qualified psychologist. Now, I'm not going to name names, well, not at the moment anyway, but this particular psychologist appeared to have taken on the role of investigator. They stepped out of their remit, their original instructions, in a criminal case, always adversarial, so no shared instructions here. But had stepped out of his remit and in fact started investigating me, my personal history, my background, my academic background, and I learned later had even telephoned a university that I had attended to check out whether I really had attended and what this qualification was all about. Now, this expert stepped out of his remit, outside of not only his area of expertise as a psychologist, because he's not an expert investigator, but also stepped out from his original instructions. The barrister representing the parties therefore raised this in court. And by that I mean the fact that I was not qualified, I should never have been an expert, and all of my evidence in this particular case, even before the case was heard, should not be heard. So my report should be dismissed, and my status as an expert in this particular case should be thrown out. I was called to what is called a voir dire. Let me say that again, voir dire. And what that means is basically it's a hearing within a hearing to ascertain a particular point, often a point of law, point of principle. And I was summoned to court to answer questions in detail about my qualifications. Now, it was incredibly stressful for me, amazingly demoralizing, devaluing, gosh, so many words. And so I went along to the court grasping all of my certificates, grasping all my letters of recommendation, commendation, awards, everything else, and went to court. And all the time I had it in my mind, why is the judge allowing this? Why is the judge allowing such a personal attack on me when I am registered with the HCPC, I'm chartered with British Psychological Society, I've been recognised as a senior psychologist, basically, with a number of awards and invitations to speak at conference, and therefore, what the heck was this about? I won't go into the gory details of the hearing itself, but suffice to say, it was probably one of the most unpleasant experience I have gone through in court, because this was about me. The attack was on me. So this case really piqued my interest, and now you understand why. To cut a very long story short, what happened at the voir dire was the judge decided that despite the psychologist's statement from the witness box that he would never employ me, the judge said and determined that yes, I was qualified. Yes, the certificates that I had presented, my registration at HCPC and all these other things were appropriate, and that my evidence was appropriate, and that we were all to reconvene in the court, I think it was the next day, to have the actual criminal hearing. I often wondered why this ordeal was allowed to go on at the voir dire for quite so long and in such detail. On one occasion, I was asked, how does the court know that the signature on my undergraduate degree was genuine? I mean, at that point, I ended up looking at the judge and shrugging my shoulders. What could I say? But why did he allow it to go on so long and to such depths? Because on the next day, at the true criminal court hearing, whenever the barrister even said half a sentence about whether or not I was suitable or qualified, or could I give an opinion, the judge simply slammed the barrister down. The case was over very quickly, although both sides were able to put their arguments, but any criticism of me was completely barred from the actual court hearing for the criminal trial completely. So let's go on to the case. Hello, I'm Susan, Dr. Susan van Scoyoc, and this is one of our little talks about current affairs in psychology. So grab a cup of coffee, have coffee with me, Susan, and I'll talk you through it. This one is about a recently released court judgment awarding a father in family court, awarding the father costs against the Association of Clinical Psychologists, whom I'm going to refer to from now on as ACP. So this is a very interesting case. That's an understatement. And I'm going to try and take you through it and highlight the points that might help you understand why costs have been awarded against HCPC. Wouldn't that be interesting? Against ACP. All right, so we have the ACP, mother, father in family court, along with Melanie Gill, who acted as the expert, the psychologist expert in this family case, and the ACP. And in fact, if you do a search, you will find that there has been quite a campaign against Melanie Gill in The Guardian and The Observer. So there's a series of articles if you want to go and search. And they are about the use of non-psychologists for assessments of family interaction, family attachments, where the case is going before the family court and major decisions are being made concerning removal of children from perhaps one parent and placed with the other, or removal of children from both. I don't know. I do not know the individual cases, and I do not know the details of, in fact, this case as it was originally heard. And that's how it should be. Family court tries to anonymise and protect the names of the families in order to protect the children. Its highest goal is to act on behalf and protect the children. That's an important point I'm going to come back to at the end of this. And just hold that in mind all the way through. So let me refer to the judgment. So you'll see I've got a piece of paper prompting me, things not to forget, and the judgment here on my tablet. So I've already basically named the parties. And this was heard before Sir Andrew McFarlane, who is himself the president of the family division. So this case basically had wound its way through the family system, and this final hearing was heard by the president of the family division. So, background that he gives in his judgment, and when you see me reading from the tablet, I am reading from his written judgment. So on 13th of September 2022, Peel, J, which is Justice Peel, the judge, granted permission to appeal to a mother who had failed in her application to another judge to reopen a fact-finding determination made in private law children proceedings in June 2021, in which the judge had made findings of parental alienation against the mother. An earlier application for permission to appeal on the original fact-finding judgment had been dismissed. And it was dismissed as totally without merit, and I'm quoting there. As his judgment makes clear, Justice Peel was persuaded to grant permission to appeal on the sole basis that the need for the court to look at the practice of instructing unregulated experts in such cases provided a compelling reason for the appeal to be heard. Well, that makes sense, doesn't it? Basically, the challenge was that the expert wasn't an expert, and that there should be a judgment made on whether or not the expert was indeed qualified to be an expert. Now I'm going to pause here, so I'm no longer reading from the judgment, and just say that I have myself been in this position, nowhere near as dramatic and grand as this case obviously grew to be, but I have been challenged on my qualifications, whether I should be recognised as a psychologist, all of those things in a court hearing. And you can hear about that in another video that we will be preparing for you. But for now, this is not such an unusual step. Saying the other person is not qualified, where there's an adversarial setup in court, where there are 2 or 3 experts, all instructed by the different parties. One side may point at another expert and say, "You're not properly qualified to do this." And the courts are used to dealing with this. But in this particular case, the expert in family court had been appointed as a joint expert. So in fact, all the parties and later the court had agreed that this person was an expert as far as the court was concerned, and therefore could provide expert opinion. I will go on. So the appeal was heard on that basis. Was the expert an expert? By Sir Andrew McFarlane. Let me scroll down. bear with me, here we are. And so the application, so the appeal was heard by Sir Andrew Macfarlane. And the appeal took 2 separate days. That's a very important point. After that appeal, the father made an application for costs against the ACP. The results of the appeal were that the expert should have been recognised as an expert, that there was no legal reason why she should not have been recognised as an expert. So the appeal made by the mother failed, but the father is now making an application for costs against ACP. So the application against ACP, and I'm reading here from the judgment, is principally based upon the court's findings as to the organisation's approach to and during the second day of the hearing. Mr. Barnes, one of the barristers, is correct in pointing to the fact that the appeal process deviated from the conventional course when the ACP intervened and themselves asserted that Ms. Gill was not qualified to act as an expert in the case. Judge Macfarlane says that this case had gone astray because the ACP had ignored the clear direction of the court as to the limited role it should have, and in particular because by filing a further full skeleton argument mounting to a direct attack on the individual expert, the association had abused the leave that the court had given for it to adduce further limited information as to its case on lack of qualification. Mr. Hale, another barrister, had submitted that the ACP had taken over the role of prosecutor. The first skeleton argument from the ACP had descended into the issues in the case itself rather than the high-level assessment of matters of principle. Now let me pause here. The matters of principle were really what qualifies one to be an expert on attachment, on relationships, on all of the things that usually are of concern to the family court. So those matters were what was expected, and the debate was expected to be on those matters of principle. The proper course for the ACP to have followed was that taken by the, and it says HCCP in the judgment, but I rather suspect that this is HCPC. So I'm going to go on that assumption. So the proper course was taken by the HCPC in its letter. The letter contained the answer to the court's question. One assumes it's about qualifications and allowing or presenting oneself as a psychologist. And the ACP should have done no more than repeat it. Instead, Mr. Hale submitted the ACP had acted in a manner which the court had expressly depreciated in its judgment. The father had not anticipated that the intervener, here the ACP, would conduct itself in this manner, and he should not have to pay his costs for responding to their conduct. So that was the father's argument. ACP replied that there had been no suggestion at any time that they may be liable for costs. that they had not intended to take over the case, and that they had been drawn into a more prominent role by the progress of the hearing. And the ACP said they had not submitted that the expert had been acting unlawfully in taking on instruction in this case. And there's recognition in the judgment that Ms. Gill herself had incurred costs in the region of £50,000, including VAT, in order to basically defend herself and her reputation. The judge felt that the mother would not have brought an appeal if not for the intervention of the ACP. In other words, that the mother didn't have grounds for appeal, but because the ACP had become involved, that there were now grounds. The judge says that Justice Peel was correct in identifying a need for the court to look at the question of the professional competence of experts, and that indeed was the focus of the hearing. The court then goes on to award costs against the ACP. So many acronyms. And this is what it says towards the end of the written judgment. It was, however, the ACP's case, both in the letter to Judge Davis from Professor Wang and within the appeal, that Miss Gill was unqualified to hold herself out as a psychologist. At the first day of the appeal, for reasons that were never explained, the ACP's counsel was unable to substantiate that claim by reference to any regulation or other authoritative statement. The appeal was adjourned to a further date, and the ACP were permitted to file a short document identifying the basis of its claim. It should have become clear to the ACP that it could not provide a clear, bright line answer to the court's request for clarity on the issues of qualification. At that point, the association might simply have acknowledged that was the case and stepped back. Instead, in its second document and during the second day of the hearing, the intervener mounted a direct and detailed critique of the expert. All right, didn't stick to, these are my words, not the judgment, didn't stick to what they were asked to do, but instead added more to critique the individual expert, not the principles of qualification. So, here's the key paragraph. Where a non-party has been given permission to intervene and becomes an intervener by reason of its special interests and or knowledge, it has a responsibility to assist the court in respect of the issues before it. Where an intervener is found to have acted beyond the remit of the permitted intervention or acted in contradiction to the court's direction and or is found to have acted unreasonably and in doing so not to have assisted the court, it is likely to be at risk of an adverse costs order. In the circumstances, I do consider that the ACP has conducted itself as an intervener in a wholly exceptional manner and in a way which is most unlikely to be replicated by other bodies who may consider intervening in family court proceedings. It is therefore fair and proportionate for the ACP to be responsible for a part of the costs of the father and of Ms. Gill. However, both the fact that no costs warning was given and the limited financial resources of the association require any costs order to be kept at a modest level. Okay. Okay, now that modest level is £20,000. And that is the end of the formal judgment. Now, a couple of comments. Anybody who's come on the training, anybody who's gone to the BPS webinar training, came to the workshops before COVID, will have heard me use a number of the phrases that are in that judgment. Here is my view of what has happened. Whenever you approach the court, even if you're approaching the court to basically tell them that they may have made a mistake and you have sound and solid grounds for doing so, you must remember that the court has a purpose and it has rules and you have to follow them. This is particularly so, in my experience, in family court, where it's always important to remember that the court is interested in the welfare of the children. It wants to make decisions that protect the children and are in the children's best interests. In this case, they allowed a challenge very late in the day, in fact, after the original court hearing, to the use of a particular expert, Ms. Gill. And that challenge was that she shouldn't be using the title psychologist and that she was acting inappropriately, at least. I mean, there's even a suggestion in the judgment that it had been suggested that she was acting unlawfully. The HCPC clearly did not confirm that view. And with ACP, it seems what they did was they stepped into doubling their efforts rather than recognising that actually they'd lost their point. They'd lost their argument. And they were given a second chance before the second day to add a short document. Instead, they mounted an argument that took the whole day. And still didn't work. It still didn't prove that this other expert shouldn't be an expert. And this comes back to not understanding that the appointment of an expert actually falls within the legal framework. It's not about us as psychologists. It's not about us as our profession. And this is a hard one sometimes to swallow, but the court, and in fact the original instructing solicitors, acting jointly on behalf of mum or mother, dad, father, and possibly any other people involved in the case, like a Kafka's guardian, anybody like that, that would have been a joint expert. They would have all agreed on who was chosen. That's an important point. Now, that choice can be later challenged, of course, but there has to be grounds for that challenge. There has to be real grounds, because the court has agreed that this is the expert and this expert is going to advise the court. If they have found the expert's evidence useful, and particularly if that expert has been used repeatedly in court and judges in the past have stated in their final judgments that, in this case, Ms. Gill's expert evidence was useful, then the court will regard her as a suitable expert. I think that point that the court has to decide was lost somewhere along the way by ACP. They also lost sight of another thing about practicing in court, another wise rule to remember. You advise the court, you do not tell them. You do not become an advocate. You do not argue and argue simply because you're not winning. You are there to advise and basically educate the court. That attempt had already been made. And so we have a case here where ACP have mounted somewhat of a campaign against Ms. Gill. I'm sure that they have their reasons. I don't know what they are. I'm not privy to that. My comments today are about, in a way, why ACP probably were shocked at having to pay costs. They had lost sight that they were acting within court procedures and rules, and you really have to follow them, no matter who you are, no matter who the judge is, no matter what is happening. So, yet again, welfare of the children, help the court, assist the court, don't make decisions for it. I hope you've enjoyed my view of this really interesting case and outcome.